Welcome to another episode of Immigration Insight. Today we're diving into a crucial topic for many immigrants, Form 1751, the Petition to Remove Conditions on Residence. Joining us is our esteemed guest, Shah Peerally, founder of the Shah Peerally Law Group. Welcome, Shah.
Thank you, Suzanne. It's a pleasure to be here.
Let's start by understanding what Form 1751 is and who needs to file it.
Absolutely. Form I-751 is used by conditional permanent residents who obtain their status through marriage to request the removal of the conditions on their residence. Typically, this applies to those who have been married less than 2 years at the time of their initial green card approval. The conditions must be removed to maintain permanent resident status.
What happens if someone doesn't file the I-751 on time?
Failing to file Form 1751 on time can result in the loss of permanent resident status and possible removal from the United States. However, there are exceptions where late filings may be accepted if the applicant can show good cause.
Now let's talk about the different types of I-751 waivers. Can you break them down for us?
Sure. If a joint petition is not possible due to specific circumstances, the conditional resident may request a waiver of the joint filing requirement. The waivers are categorized as follows. 1. Extreme Hardship Waiver. This applies if the conditional resident can demonstrate that removal would cause extreme hardship. 2. Divorce Waiver. If the marriage ended in divorce or annulment but was entered into in good faith, this waiver may apply. 3. Abuse Waiver. If the conditional resident or their child was subjected to abuse or extreme cruelty by the United States citizen or permanent resident spouse, this waiver can be requested. 4. Death of Spouse Waiver. If the United States citizen or permanent resident spouse has died, the conditional resident can apply for this waiver.
That's a comprehensive overview. What kind of evidence is required to support these waivers?
The evidence varies depending on the waiver type, but generally includes extreme hardship waiver documentation such as medical records, financial records, or expert testimonies showing the hardship, divorce waiver, finalized divorce decree, and evidence that the marriage was bona fide, like joint financial records, photos, or affidavits from friends and family, abuse waiver, police reports, medical records, affidavits from social workers, or shelter records that document the abuse, death of spouse waiver, death certificate, and evidence that the marriage was genuine.
What laws govern the I-751 process and these waivers?
The main law is the Immigration and Nationality Act, specifically Section 216, which deals with conditional permanent residence based on marriage. It lays out the requirements for removing conditions and the circumstances under which waivers can be granted. Additionally, various USCIS regulations and policies provide further guidance on processing these petitions.
Before we wrap up, any final advice for our listeners?
Yes, it's crucial to understand that filing an I-751 and requesting a waiver is a complex process. It's advisable to seek legal guidance to ensure your petition is thorough and well supported. Our team at the Shah Peerally Law Group has extensive experience handling these cases, and we're here to help.
Thank you, Shah. For our listeners, if you have questions about I-751 or need assistance, you can reach out to the Shah Peerally Law Group at 510-742-5887 or visit their website at www.peerallylaw.com. Thanks again, Shah, for joining us.
Thank you, Suzanne. Always a pleasure.
And thank you all for tuning in to Immigration Insight. Until next time.